First of all, hello everyone. Thank you very much for joining us. My name is Nick Macklam. I'll be sharing with you some top tips about advising clients and instructing counsel in the context of private client disputes. Then my colleague Poppy will talk to you about the interpretation of the word children in documents and section 33 of the Wills Act. Now, when we first launched our junior programme of seminars, we wanted to offer something a bit different, something aimed at junior solicitors with a view to sharing both knowledge and experiences. And when I was asked what I wanted to talk about in my session, I thought it might be a helpful and interesting exercise for me to reflect on and share with you some of my experiences in acting in private client disputes since I first joined Radcliffe back in 2014. So that's what I'm going to do. You can see the title of the talk on the slide. It's going to involve us dipping into different areas as I give different examples, so 75 Act claims, claims about the administration of estates, claims about removals of personal representatives, and so on. I've got 7 tips in total. I'll spend more time on some than others, and I hope you find it helpful. So if we kick off then, the first tip is about getting capacities, responsibilities, and rights clear when advising. Now, private client disputes are in some ways more unusual than a straightforward set of civil proceedings because it's not uncommon for your client to have more than one role in the context of a dispute. So that the same people wearing different hats at different times is not unusual in the context of private client disputes. And so my first tip is that it's really important to be clear from the outset with the client about the capacity or capacities in which your client is acting when coming to see you for advice, and what his or her rights and responsibilities are when acting in the relevant capacity. Now that's a fairly obvious point when you think about it, but it can sometimes be overlooked. For example, your client could be a beneficiary of an estate, which is the subject of a 1975 Act claim, or your client could be the executor of that estate, but not a beneficiary. Or, and this is quite common, your client could be both an executor and a beneficiary of the estate. Now, obviously, the most straightforward scenario is where your client only has one capacity, but where your client has 2 capacities, things can get more complicated. In that situation, you need to be constantly alive to which capacity your client is acting at any one time. And that can affect not only the advice you give, but also the position in relation to the recovery of your client's expenditure in taking advice, and whether others can see the advice. So to give one example, if your client seeks advice in relation to a dispute between beneficiaries in relation to the administration of an estate, and your client does so in his or her capacity as an executor, your advice will obviously need to be tailored to the rights and responsibilities of an executor. And that's a topic that could fill a talk on its own, but you know that the basics: remain neutral, seek directions from the court if need be, and so on. So the advice needs to be tailored to the particular rights and responsibilities of an executor if your client is seeking advice from you in that capacity. The cost of taking the advice will normally come out of the estate, and in giving that advice for the benefit of the estate and paid for by the estate, it needs to be prepared on the basis that in principle other beneficiaries can legitimately ask to see it. However, if the same client is both an executor and one of the beneficiaries who has a particular position in relation to the dispute, it's really important to be very clear and to separate the advice given to that person, on the one hand in their capacity as an executor, and on the other hand, advice given to that person in their capacity as a beneficiary with a partisan position, the cost of which would not be borne by the estate and would be privileged and couldn't legitimately be asked for by other beneficiaries. Now, I emphasize this because being very clear about the capacity in which your client is acting when you're advising isn't always done in practice, and it can lead to problems and confusion. Clients can be confused about their rights and responsibilities, There can be questions over what is and is not privileged against beneficiary of the estate, say. And the relevant capacities can sometimes become blurred, and sometimes that can have some adverse cost consequences. So my next tip relates to cost recovery. And as you know, one of the most important things a client wants to know, after you've told them how much you'll be charging for the services you provide to them, is whether they'll be able to recover those costs from somewhere, whether from a deceased person's estate or from an individual that they are having a dispute with. And this is really important to get right in private client disputes in particular, because the cost position can be much more complicated than in ordinary civil litigation. And it's not always a point that's emphasised well enough to clients. And I've seen that particularly in two situations. The first is where the dispute is about what executors are doing or not doing in relation to estate administration, in circumstances where their behaviour may annoy your client, but it doesn't amount to misconduct. In that situation, clients really need to know and understand that the costs, the prospects of getting an adverse costs order against executors in those circumstances may be pretty minimal in the absence of misconduct or unreasonable behaviour. Another scenario that this crops up is where executors take a partisan position in relation to a dispute because they haven't been advised correctly about their rights and responsibilities as executors, and they consider they'll be protected from an adverse costs order by their right to an indemnity. And in that situation, obviously, clients need to know and understand that a partisan executor is not likely to benefit from the indemnity. And these are points where, again, clients can become confused, and importantly, it can lead them going down a path that they would not otherwise go down if they were very clear from the outset in their own minds about the cost position. So it's an obvious point, but it's one that as advisors we need to be mindful of at all times. I mean, in typical civil cases, the cost position may not be very difficult. If you win, your client will recover their costs probably about 70%. If they lose, they'll have to pay the other sides. Whereas in private client disputes, the cost position can be much, much more complicated. You have special rules applying to particular individuals like executors, and it can be complicated even further where some people have and are acting in more than one capacity. So it's not uncommon in my experience for clients not totally to appreciate what the cost position is, and for advisors to have to remind them of it again and again at appropriate moments, most obviously when they're thinking of taking a course of action that may well have adverse cost consequences. The next tip relates to proportionality and remedies. And this is particularly relevant when dealing with disputes involving a relatively small estate. Now, you'll all know that private client disputes often involve family members in dispute. They can get heated, they can get emotional. And as advisors, it's important that we maintain a clear head and a clear focus in advising how to deal with the dispute in a proportionate way. And this is particularly acute in the context of applications to remove someone and replace them as an executor. It's not uncommon, in my experience, to be asked to advise on applications of that nature. And it's not uncommon for that advice to be sought in the context of an estate which is of a relatively low value. In fact, it's actually much more common because with a larger estate, you're much more likely to have professionals either doing or being involved in the administration. Whereas with smaller estates, it's not unusual for it to be administered by a layperson without legal assistance. Now, applications to remove and replace an executor can be expensive if one factors in correspondence that occurs pre-action, preparation of the court documents, at least one hearing, and so on. And so there's a few points I'd make about those sorts of disputes, as I say, in the context of smaller estates in particular. The first point I'd make is that it's really, really important not to allow such proceedings to be used as a forum to ventilate disputes between the parties, which are not essential for the court to resolve. And it's very, very common to see that happen in the context of removal applications. That point can be made in other contexts too, particularly, say, 1975 Act claims, where it's not uncommon to see in witness statements sort of really lengthy moans about the other party's behaviour, which on analysis doesn't have any real bearing on the issues the court has to decide. But the courts have been very, very, very clear. They do not want proceedings of this nature to be used as a forum for parties to have and ventilate disputes about one another. And so as advisors, we need to make sure that we're advising their client on what is and what is not relevant. It's really important. It keeps the statements shorter, it costs the client less, and it keeps the courts on side if they see a properly focused, tailored statement that deals with the relevant issues and nothing irrelevant. The second thing I'd say about disputes of this nature is that when we're advising, it's really important to think practically about what the court might do in the particular context of a relatively small estate, and how the dispute could be resolved in a more proportionate way than one that involves lengthy contested hearings. So in more than one case I've been involved in involving a removal application in respect of a personal representative, the master has given the parties a very clear steer that rather than have a spat about whether an existing personal representative should be removed and a replacement nominated by the applicant appointed instead, it would be a far better use of the party's time and money to try and agree, say, for a neutral third party to be appointed, which avoids the need for an expensive dispute about an expensive and contested dispute about whether the threshold for removing a personal representative has been met. And the third thing I'd say about disputes of this nature is that it's also, I think, really important to think about whether removing and replacing a personal representative will actually resolve the problem, the underlying problem. Because in my experience, it's not uncommon for a removal application to have been prompted by a dispute about what an executor either should or should not be doing. And if there is a genuine and legitimate disagreement about what that person should or should not be doing, then replacing them with someone else, say a neutral third party, may well not really help matters, because that replacement personal representative may well find themselves in exactly the same position. And in those sorts of scenarios, what may really be needed is actually directions from the court that will assist the executor in deciding what should be done in circumstances where beneficiaries are at odds about what should be done. So our next tip is about language and tone in correspondence. This can be quite a fun topic. I've already mentioned that private client disputes can get heated. Often it involves family members. Emotions run high. Now, in theory, clients come to us because we are not part of the dispute. We can give objective, clear-minded, independent advice, and we can carry out the conduct of the dispute on their behalf in a professional and dispassionate way so as to maximize the prospects of resolving it satisfactorily. So that's the theory. In practice, I often find that clients want our correspondence not to be objective, not to be clear-headed, not to be independent, but instead to convey the raw emotions that they are feeling in as heated and aggressive way as possible. In other words, we get asked to be a proxy for our client's emotions. And I cannot emphasize enough that it is a very bad idea to agree to go down that avenue. Not only does it potentially raise professional conduct issues, depending on precisely how grumpy the correspondence gets, but it's counterproductive, it's positively harmful. And that's because it makes the dispute more difficult to resolve. It usually damages the relationship you have with your professional counterparty. In my experience, it achieves nothing. No one ever reads an angry letter and thinks, oh, okay, let's give up. Actually, it tends to entrench positions rather than result in positions moving. And judges end up looking at it with horror. And I have various experiences of sort of uncomfortable hearings before masters, as the master's working through some of the correspondence in the bundle, and the jaw is gradually dropping. The Civil Litigation Brief blog, which is very good and you can find online, has a collection of interesting cases and notes on the subject. I'd encourage you to have a look at that at your leisure. It notes, among other things, that one consequence of intemperate correspondence can be indemnity costs. And in that event, a complaint or worse from the client to their solicitors is to be anticipated. So by all means, make your correspondence firm where it needs to be, but make sure it's professional, dispassionate, and appropriately focused, and something that you would be entirely happy for a judge to read. Remember that it's your firm's name on the note paper, it's your name on the letter, it's you who has conduct of the case, and it's ultimately for you to exercise your professional judgment on the right tone and content of your correspondence, and advise the client accordingly. The next tip is about forms of ADR to consider. And I've got no doubt that you all have experience of clients coming to you and saying, oh, I want my day in court. This is a matter of principle now. Let's fight it all the way. Not at all uncommon to have that. It's also not uncommon to have a client come to you months or years into a piece of litigation, perhaps just before trial. The pockets are emptier than they were. They're looking pretty anxious about the prospect of having to go to court, and they're asking you, well, can we get out of this? How do we bring this to an end? Sadly, often in that situation, it can be too late because the parties have spent a lot of money on their lawyers, and they want to and need to fight it out at trial and see if they can get a cost order that benefits them. So that situation can be avoided by thinking about undertaking at an early stage alternative dispute resolution. We do that for two main reasons. First, it's usually in the client's interests. Unless they have an overwhelmingly strong case and it will cost very little to litigate it, which is seldom the case, it's in the client's interest to try ADR. Most cases can and do settle. But it's also the case that many cases settle late in the day when a deal could have been done earlier. So that's the first reason we do ADR. The second reason is that the courts expect it, and they encourage the parties to do it. And I think there are three forms of ADR that are particularly worthy of consideration. Number one, mediation. Number two, early neutral evaluation. And number three, chancery financial dispute resolution. And I'll just speak to you briefly about those in turn. So everyone knows what mediation is, so I won't spend time dwelling on that. I've got 5 tips in relation to mediation. The first is have the mediation at the right time. The earlier the better. But if the dispute is unlikely to be capable of settlement without, say, a key piece of evidence, then ensure that that evidence is available beforehand. Otherwise, you risk the experience being a waste of time. Tip number 2, select a good mediator. Counsel can often assist with identifying someone appropriate, and there are different types of mediator with different strengths, and identifying the right person can actually be very important and influential on how well the mediation goes. Tip number 3 is think through with the client before the mediation what they want to achieve. if it's a sum of money that's principally in dispute, what's the bottom line? What advice has been given to them about the merits? It's never an ideal experience if the client, the solicitor, and counsel all rock up to a mediation, each have different ideas about the merits beforehand, because then a lot of work actually needs to be done in the mediation to manage expectations, shift the client's thought process, and so on. Tip number 4 is thinking through practicalities in advance. So one important point, particularly in the context of private client disputes, is whether any settlement agreement will need to be approved by the court, which will be necessary where a protected party is involved. And the final tip, number 5, is get ready for a long day. Mediations frequently last late into the evening. That's quite annoying, but parties' minds tend not to focus before then. Ways of discouraging that can include the lawyers and the mediator being on an hourly rate after a certain time, but in practice, long days are very typical. So that's mediation. Some of the more exotic areas are the ones I'm about to turn to. So the first is early neutral evaluation. This is a concept which involves an independent party with relevant expertise expressing an opinion about a dispute. It's unlike mediation because a mediator acts primarily as a facilitator, and the mediator might offer some reality testing, testing the strength of the party's case by asking them questions. But that doesn't always happen. Some mediators aren't keen to do it. Whereas the person undertaking early neutral evaluation provides their opinion based on information provided to them and by the parties, and can do so either on the papers or after hearing oral submissions. Unless the parties agree otherwise, the opinion is non-binding and it's without prejudice process. It's still not very well known that early neutral evaluation is offered in the Chancery Division by all judges. It can be particularly useful in cases where there are only a handful of issues, or where there's one particular issue that lies at the heart of the claim, and an opinion on that issue by a judge effectively can help unlock the dispute in a way that a mediator couldn't do that. The Chancery Division doesn't have set procedures for early neutral evaluation, so the judge who will conduct it will give directions for its preparation and conduct as they see fit, but usually there'll be written position papers and a short hearing. They can be undertaken at any time, but probably the best time to request one is at a CMC or a first hearing. And there are specimen directions in the Chancery Guide, which I have fed into the slide here. And I understand that these will be sent to you after the talk's finished today. So I won't read them all out. The next topic is Chancery financial dispute resolution. This is summarised on the slide. There's more detail that you can find in the Chancery Guide. It's a process whereby a judge effectively facilitates negotiations and may provide the parties with an opinion about the claim or elements of it. It takes place at a Chancery FDR hearing. It's effectively a meeting similar to an initial session at a mediation. So it's sort of halfway house between a mediation and early neutral evaluation. It's non-binding and it's without prejudice. As with early neutral evaluation, there are some specimen directions given in the Chancery Guide in relation to FDRs, and these are set out on the slide as well. Next to tip 6, this relates to timings for instructing counsel and the steps to take before doing so. Now this is quite a practical tip, but it is important and I think not often addressed. I'm not going to say out of obvious self-interest that the time to consult with counsel is within moments of first meeting the client, and you should consult with us at every possible moment thereafter. I actually think the best moment formally to consult with counsel for the first time is after the solicitor's done much of the upfront work, and the time is right to prepare a formal letter before claim. So I think prior to formally engaging counsel to advice, the key evidence needs to have been gathered. That, I think, is really quite important, both in terms of giving counsel being able to give effective advice, but also managing the relationship with the client. Because sometimes the position is such that the case has been going on for a particular period of time. You go to counsel for an advice or have a con, and the first thing counsel says is, well, actually, I need to see this long list of documents. And the client's all geared up to be given advice, and they then find they have to wait, and they get disappointed. Obviously, counsel can and should be asked to advise on any gaps in the evidence, but I think a reasonable amount of upfront should be done before instructing counsel in sort of gathering the relevant evidence to enable counsel to advise comprehensively. Now, that's not to say counsel should not be approached before all the key evidence has been gathered. If I may speak on behalf of all of Radcliffe Chambers for a moment, we're always happy to have an informal conversation with solicitors prior to being instructed to give pointers if that would help. So the solicitor might say, well, we want you to advise on X in due course. Do you think you'll need to see Y in order to do that? Or you might say, this is what we've got so far. Do you think you'll need more in order to advise? So please don't be shy about making contact in that way. Final tip is keeping the case under review and managing expectations. And one of the points I'd make in this context is once you've sought counsel's advice, if it's at an early stage, please don't let that be the last thing we see of you until trial. It's really, really important to keep a case under review, particularly in private client disputes where very often the case can turn largely on facts rather than law. And if the case is such that it will involve counsel at one stage or another, I think it's really important to seek counsel's input at appropriate points, particularly in relation to the preparation of evidence and considering the other side's evidence, because then counsel can advise appropriately on both the merits and settlement offers and so on. And it's not uncommon that counsel will advise at an early stage, and then things will change as the evidence comes in and the case develops. So I think it's important that solicitor, counsel, client keep in touch throughout the context, throughout litigation. I think of it sort of working as a team throughout rather than as a sort of purely consultant role. The final point is just to say that managing expectations of clients is also very important. It's common for clients to lose sight of the wood for the trees as a case progresses, or to downplay in their mind some of the more negative aspects of advice that they've been given at the start of the case. And so managing expectations and reality checking, I think, is important throughout to avoid the all too familiar feeling of the client gets to trial and actually they think, well, they may not be up for it after all, and let's see if we can settle, and it's all too late. So those are my tips. I've run slightly over time, but I hope they've been of some use to you. And thank you very much indeed for listening. And I'll now hand over to Poppy.
That was incredibly interesting, Nick. I know I found that very useful to hear your top tips. I'm sure everyone else did as well. I'm just going to share my screen. So as Nick said at the start, I'm going to be talking about issues with issue. What do I mean by that? Well, the two areas of focus for my talk today are going to be the interpretation of the term children in testamentary documents, and the effect of section 33 of the Wills Act 1837. Children are a sort of a key beneficiary in a lot of wills. People do tend to leave their estates to their children. So obviously the term children is a very important term that we come across in wills. And the effect of the section 33 of the Wills Act is basically to ensure that if you leave a bequest to a child or a remoter descendant, but then they die before your death, that gift won't lapse, but will then go to their issue, the intended beneficiary's issue, if they leave any issue at the time of the testator's death. So that's my focus for today. And before we start, it's just useful to remember what the sort of backdrop is for interpreting testamentary documents. And we're all familiar with Macklam ruling, Supreme Court case, where we're told you've essentially got to interpret a will just as you would a contract. So we're sort of looking for the objective intention of the testator or the testatrix by looking at the will itself, the clause in question, but also the rest of the will, and the facts known and assumed to the parties and common sense. And we ignore the subjective intentions of the party itself, of the testator. So in any case where you're trying to construe a will, the first step is the will itself, goes without saying. There is also Section 21 of the Administration of Justice Act, I've just mentioned there, which does allow the court to admit extrinsic evidence as evidence of the testator's intention in interpreting a will. But Section 21, as we all know, only applies in certain circumstances. So if the will is meaningless, if the language in any part is ambiguous on the face of it, or if evidence other than testator's evidence of the testator's intention shows that the language is ambiguous in light of the surrounding circumstances. So that is a potential provision, but it's not always going to arise on the facts. So turning then to looking at this term children. So hopefully the testator or the testatrix of the will that you're looking at has specified by name exactly who they're leaving their estate to. And would always advise that if someone is in the process of drafting a will. But when you are administering a estate or helping someone administer a estate, you might end up with a will that's got a clause along the lines of leave my residuary estate to such of my children as shall be living at the date of my death. And we also get trusts as well that are going to specify classes such as children. And if you've got a will where they've left their residuary estate to their children, but in fact the testator in question has one child that they had during a marriage, they've got one stepchild, and then they also have one adopted child, and so on, what do you do? Well, hopefully, as I said, the will is going to tell you what to do, but if not, the legislation and case law over the past century or so has developed quite considerably to help us in construing that term children where it might not be clear on the face of the will. So I'm just going to do a sort of whistle-stop tour of some of the key provisions, looking at certain categories of children that hopefully would be able to benefit under the term children. But this is a whistle-stop tour, so if you come across one of these disputes, obviously got to look at the practitioner's texts in detail, or of course instruct counsel from Macklam chambers. So the first category of children I'm just going to mention is adopted children. So adoption was introduced under the 1926 Adoption Act, but it didn't immediately treat adopted children in the same way as other children when it came to wills. The position changed for deaths on and after the 1st of January 1976, and after that basically makes no difference if the child is adopted. But in terms, and as Nick said, the slides will be sent out, so if you don't have time to read them, hopefully you will have later. But so that was the position for deaths prior to, after 1976. What about deaths prior to 1976? Because the rules were different. Where you had a will executed before the 1st of January 1950, then you had children, they didn't include adopted children in wills unless a contrary intention was shown. And then when you had wills executed between 1st January 1950, it should say, and 1st of April 1959, it did include adopted children unless the contrary intention was shown. And then we had a subsequent change in the Adoption Act 1958 as well. So this was changed over time prior to 1976. Most of the time, these provisions are unlikely to have an impact on the cases that we're dealing with, because this is deaths prior to 1976. But there will be rare cases where they do have an impact. Say, for example, you've got a will trust that's been set up under a will. And in the rare case they do, the significance of these rules is likely to be reduced following the enactment of the Human Rights Act which makes the European Convention on Human Rights enforceable. This was seen in the case of Han's will trust that I'm going to be mentioning later and when I just come to the potential human rights issues. So the next category is illegitimate children. So I put up there that what we mean by illegitimate children is children not born, conceived in marriage valid by English rules of conflict of laws, or not legitimate by the law of domicile of each parent at the child's date of birth. So since 1970, the reference to children have essentially been construed as including illegitimate children through two family law reform acts. But what about the situation prior to 1970? So for wills executed prior to that date, 1st January 1970, it was the common law position. And the common law position was that child, son, issue, all those sorts of terms, they meant legitimate child. And so if you had gifts to children, generally that was to be construed as not including illegitimate children, although there are some exceptions that are worth looking at if you come across a case that deals with this. As with adopted children, it's unlikely that you're going to come across wills executed before 1st January 1970 commonly in a lot of the wills that we are administering and construing, but it can happen. And obviously the courts can use rules of construction, but as I said, they've also got the Human Rights Act and the Convention rights that are now enforceable under the Human Rights Act, which may be able to assist. And there's a case that concerned illegitimate children. It's called J.C. Druce settlement, which again, I will come on to in a moment. There's also another category, which is legitimated children. So children that are made legitimate by subsequent marriage. They always had a bit more of an open door than adopted children or illegitimate children did to inheriting. So even pre-1927, if you were legitimated by subsequent marriage, then you could inherit personal property and real estate. You couldn't, for example, inherit titles and so on, but you could still get personal property and real estate. This was changed by a series of acts over the 20th century that sort of chipped away at the rules. At first, it was you could become legitimated and then you could inherit, but only from, you were treated as if you were born from the date you were legitimated, which is slightly bizarre. And gradually that had been chipped down, and then we get the Legitimacy Act in 1976, where you had legitimation by subsequent marriage, and means that the child takes as if they're born legitimate. I've just also mentioned the Family Law Reform Act, because obviously the position on illegitimate children should also apply to legitimated children. And the only thing other than to bear in mind is common law rules do continue to exist for alongside the statute for certain circumstances. So for example, where a testator died prior to 1976, common law rules could apply in certain circumstances. So the other category is stepchildren. Stepchildren are not included in children. So will can specify that the children should include their stepchildren, or it might name stepchildren by name, but it doesn't automatically include stepchildren. And in this day and age, blended families are more and more common. I've been in a family that's a step family, and so this is an issue that could occur more and more. And it also, although I'm sort of focusing on wills today, it's an issue on intestacy, because stepchildren aren't going to inherit. I've had cases before where, my client has been told by their step parent, oh, you'll get everything, you'll get your share on my death, but that's just not going to be the case unless there is a will that makes sure that they inherit. So it's just something to bear in mind, which I think is going to become increasingly prominent as well. It's another category which I'm not going to go into in detail, because there's been a lot of legislation and there are extensive rules relating to children born by assisted reproduction. So that includes artificial insemination, surrogacy, placing of embryos and sperm and eggs. I can't go into the full details here, but it's just important to bear in mind that there are several different acts. and they've got different time periods for when they apply. And so the rules might be different if you're dealing with beneficiaries that were born by artificial insemination or the placing of embryos or eggs in sperm. Another topic is the Gender Recognition Act. And so this applies to transgender beneficiary children. And I think it has the potential to become a greater thing that's going to occur, a more common thing that's going to occur in wills moving forward. And the basic rule under the statute is that if the will's been made prior to the 4th of April 2005, then the will is just read as if, according to the transgender beneficiaries' birth certificates, their sex at birth. But if the will is made after that date, then the will needs to be read according to their acquired gender. And this could have some undesirable results, because if you have a will saying I'm going to leave half to my daughters and half to my sons, and you've got 2 daughters and 2 sons, and then one of them transitions, so then you have 1 daughter and 3 sons, that's going to potentially lead to an unfair result where the one remaining daughter gets a sort of a windfall compared to what she would have received. The obvious solution is to use, when drafting, use gender neutral terminology in wills, and also specify people's names, and also update wills regularly, so as to ensure that they reflect what people actually mean in their wills and where they want their testamentary dispositions to go. But there is this saving provision, Section 18 under the Gender Recognition Act, which means that you can apply to court where a disposition has basically is different from what it would have been, but for the fact that this person's gender has become the acquired gender under the Act. I couldn't find any reported cases on Westlaw yet in relation to Section 18, so it looks like there's still an application to come. And then just turning then to some of the human rights issues that I mentioned before. The legislation that I've sort of run over, when that was brought in, for example, in relation to illegitimate children or adopted children, it's prospective, not retrospective. So hence why I said position is different after 1970 or 1976. And the European Court of Human Rights, the case law there encourages that there shouldn't be any discrimination against adopted or illegitimate children. So it encourages a sort of a retrospective approach. And so you could try to argue for potential infringement of the Convention rights, which have become enforceable under the Human Rights Act. And as we'll remember from our days of studying Human Rights Act at university or on the law conversion, Section 3 of the Human Rights Act says that when reading and giving effect to primary and subordinate legislation, so far as it is possible to do so, it must be read and given effect to in a way that's compatible with Convention rights. So at least for the time being, while we still got the Human Rights Act, Section 3 does apply, and you can potentially read down legislation. But the Human Rights Act is generally considered not to apply retrospectively. So it can apply to older legislation, but it doesn't apply to events predating the Act, a particular Act in question. The case of Re Erskine, that's the first one on the slide there. That was assessment that was established in 1948, and it included the term statutory next of kin, which on the basis of the legislation as it was, wouldn't include adopted nephews. But the judge there held that the convention might operate retrospectively, but only if it was fair in an individual case. It was relying on a House of Lords case called Wilson. And he said on the special features of that case, he could apply the Human Rights Act retrospectively so as to construe the 1948 settlement so that the adopted children could take. We then come to Rehan's Will Trust. And there it was a will dated the 6th of May 1946. The testator left the residue of the estate to his children in equal shares for life, with the remainder to their children upon them attaining the age of 21. And one of the children of the testator actually adopted children. And so that child who had adopted children, he then later died in 2008. And it's a question of whether these adopted children could take. The judge in Miss Justice Rose in Rehand's Will Trust held that Erskine was actually wrong, and the Human Rights Act couldn't operate retrospectively, where the result of doing so would be the fair one. But she thought that you could read down, according, applying Section 3 of the Human Rights Act, you could read down the relevant section of the Adoption Act 1976, which prevented the latest legislation from applying to this existing instrument, this will that was from 1946. So you could apply that to the testator's will. And she said that was because the proper interpretation, the issue about the proper interpretation, actually only arose after the enactment of the Human Rights Act. That was on the testator's child's death in 2008. And she also said that the rights were not yet vested in the adopted grandchildren. And when she said vested, she wasn't talking about it in the terms of that we understand under trust and inheritance law, but more in the sense used in that House of Lords case, Wilson, and the retrospective effect of the Human Rights Act, where it was in the sense that the particular beneficiary of a right must have done something to avail himself of it before the law is changed. So it was sort of that was the approach that she took in there, and she was saying that actually this wasn't a retrospective application of the Human Rights Act, because it's only falling to be considered after the enactment. Re-J.C. Drew settlement, this was about a settlement made in 1959, and that was, the issue there was about whether illegitimate children could take. And again, the applicable act was read down to make it convention compliant. And in doing so, the court applied hand and held that basically the distributions that were being made under the settlement, while before the enactment of the Human Rights Act, that would be unaffected by the Act. Settlements of further distributions under the settlement that came afterwards could be affected by the Human Rights Act. So those are the sort of three of the key cases that have happened just in the last 10 years. And quite a lot of commentators think that hand was a step too far, and really actually is a retrospective application of the Human Rights Act, and also exceeded the limits of what's really allowed by Section 3. Yes, you're meant to read legislation as far as possible, but it's as far as possible. It's about maybe stretching the interpretation, but it's not literally amending the legislation. And the case that I put up there of I think it's PQ and RS, that was decided on an alternative basis, but it was said in that case that there's got to be doubt that hand will be followed. And there is a conflict between Erskine and hand, and that hasn't been resolved yet by an appellate court. So this is a potential route for you if you do find yourself in a situation where you're dealing with rules that are potentially are discriminatory against adopted children, illegitimate children, and so on. But that there is this question mark over that, so just sort of sensible to treat it with some caution. So takeaway points. Key one, it says as stepchild myself, stepchildren not included. Adopted, illegitimate and legitimated children, though, probably will be included. But if you're dealing with historic documents or historic deaths and so on, look to the previous law, to look at the textbooks, instruct counsel. And even if the previous law does apply, you could consider whether the Human Rights Act and the ECHR will be applicable. So now coming on to Section 33 of the Wills Act 1837. So again, this is an issue about bequests and devised to children, and what happens to them if the intended beneficiary has died before the testator's death. So as I said at the start, what Section 33 does is operates to make sure that a gift to a child or a remote descendant doesn't lapse if that person has died, but if it doesn't lapse if they've left issue, provided the issue is living at the testator's death. Section 33 has effect unless a contrary intention appears by the will. So the question then becomes, when is a contrary intention shown by the will? So if you have a request, for example, to all my children who are alive at my death, or to such of my children who survive me, is that enough to be a contrary intention? And you know, this does come up, this issue, because you do have scenarios where, for example, if you've got fragmented families, I had one where we had a fragmented family, and there was an issue about whether you know, grandchildren of one of the children of the testator were going to be able to take under, or we're going to inherit under the will because of the effect of Section 33 of the Wills Act. So the sort of the key turning point case was Hydes and Macklam, which I'm going to come on to in a moment, and that was in 2017. But prior to that point, there had been two contradictory cases. The first one was Ling and Ling, and in that case, there was an application for a declarations that the claimant was solely entitled under the will. And the relevant clause in that case was that the bank shall stand possessed of my residuary estate upon trust for any of my children or child living at my death. So in Ling and Ling, it was held that there was no intention to exclude the intended beneficiary's issue from taking his share. So they said there was, the court said there, so there's no contrary intention. We then come to Rainbird and Smith. And this was an unopposed application for the rectification of the will, but the judge said, well, actually, I can approach this first by way of construction and deal with it that way. And there the clause was, I give my estate to my trustees to hold the residue remaining and income thereof upon trust for such of them my daughters as shall survive me, and if more than one, in equal shares, absolutely. So quite a similar clause there. And what happened in that case was that the judge distinguished Ling and Ling, said that not much guidance can be taken from what was a construction of a particular badly drafted document. It said the focus should be on the document at hand, whereas actually it really seems that the sort of intention of them seems actually quite clear, and the same in both. So then turning to Hydes and Macklam, as I said, this came in 2017. This was an application for a declaration that the claimant was entitled under the will in question. And the relevant clause was, I give, devise and bequeath upon trust for such of my sons and other children who shall be living at the date of my death, and if more than one, in equal shares, absolutely. And the judge here, Timothy Fancourt QC, held that there was no contrary intention showed by the will here, and he considered the previous authorities and approved Ling and Ling and disproved Rainbird and Smith. He agreed with Ling and Ling but didn't show actually any contrary any intention to exclude the issue. And as to Rainbird and Smith, he said that that was a decision given on a rectification claim where all the parties were in agreement as to rectification, and actually said it was really a Section 21 the Administration of Justice Act case. Only the claimant was represented in court, and the basis on which Ling and Ling was distinguished was unconvincing, and gave some helpful guidance as well. So, as he said, contrary intention doesn't have to be expressed in any particular way, and there doesn't need to be a reference to Section 33. But you've got to show by the language of the will that the divisal bequest should not take effect so as to go to the living issue of the deceased beneficiary. So, for example, a clause for substitution might be fine, that might show a contrary intention, but the mere fact that the will would have a different effect otherwise is not enough to show a contrary intention. And so the relevant question is not what does the clause mean, but does the will show an intention that Section 33 shall not have effect? And since then, Hydes and Macklam has been endorsed and applied by the courts. And so in Naylor and Barlow, it was endorsed. It was followed in Ashton and Braxton. That was, again, a case where a clause where you had given, devise and bequeath all my real estate and personal property for such of my children as shall survive me. So again, no contrary intention. And Burns and Bean was a bequest to, well, it said to my trustees shall then distribute the balance equally among all my children who are alive at my death. And even in that case, following Hives and Matchin held no contrary intention. So sort of takeaway points in light of section 33, well, because, you know, when I've looked at this before, my instant reaction when you know, I looked at a clause such as that, saying such as my children who are alive at my death, I instantly thought, oh, well, that's enough to show a contrary intention. But that's not the case, as we can see from the case law. So I think this isn't necessarily an instinctive approach by the courts. So it's quite important to bear this in mind. When drafting testamentary documents, show the contrary intention clearly. So the best thing to do, if you don't want it to apply, is to say that there's, to put a specific statement in that section 33 is not to apply, or to make a substitutionary gift. That's if you don't want it to apply. And when administering wills and dealing with issues of construction, just keep that in mind, the effect of section 33 and the case law. Because as I said, you know, I don't think it's always the most sort of, it doesn't seem to me anyway, the most instinctive approach. But of course, each will be considered within its own context. And, you know, if all else fails, it might be possible to apply for rectification under section 20 of the Administration of Justice Act, or apply to admit extrinsic evidence if the circumstances permit. So that's all I had to say about children and section 33 of the Wills Act today. Just want to thank everyone for attending today. Obviously, if anyone does have any questions, please do feel free to get in touch, and we'll be very happy to answer any queries that you might have. So thank you all very much.